Assalamualaikum. I am Nurul Fatihah binti ROSLAN and my metric number is 056814. In this video, I will be briefly explaining on Sexual Harassment Act provisions and the correlation between Western and Islamic jurisprudence assimilated in this act. Why? That will be the first question and relevant to us. Frankly, there will never be a precise answer on that question because it's too impossible to answer it comprehensively and face the first idea that comes to people's mind when they first heard about this act. But I would like to shine a spotlight on the essence of this act. This act intended to redress any person who has been sexually harassed within the definition of this act and to nurture the awareness of sexual harassment and to also cover incidental matters within the scope of this act. Briefly touch on the skeleton, this act consists of 5 chapters, namely preliminary, offences, accountability, punishment, and other pertinent matters. For the individual presentation, I will only explain Chapter 2 concerning offences, meaning it will confine to what kind of acts or gesture, be it verbal or physical, that will fall within the ambit of sexual harassment acts. This particular chapter are divided into 2. What forms of act may constitute an act of sexual harassment, and another provision will illustrate elaboratively circumstances that is equated to sexual harassment act. Crucial to note that these circumstances drafted may not be exhaustive and not cover everything that can possibly be regarded as sexual harassment. Thus, the flexibility clause in these provisions has allowed the court to interpret the provisions using a liberal approach, which sexual harassment acts can be regarded as such, though it is not specifically provided in the provisions. For the jurisprudence analysis, both provisions inserted in Chapter 2 are mainly based on sociological scope of jurisprudence, but with the mixture composites of other jurisprudence schools. As far as concerned, sociological jurisprudence talk about social phenomena where the law itself derived from the society, the people, not from the legislation. Meaning, law is formulated to govern the behavior of the society. It works as a social institution where it will impact the society's level of discipline. Or I can narrow it down, the concept is where problems within society emerge, the law is there to preserve the innocence of people or to knock some sense behind the social issues in maintaining their level of disciplines. Back to our provisions of the Act, it is an attempt to address on how Sexual Harassment Act might have occurred which adversely affected the victims, either physically and mentally. These issues emerge from people, therefore, law must work as a vehicle of social institution to respond to this issue, salvaging the affected people by satisfying the need of law presence to fix the issue regardless of genders and other incidental matters in a way to include all probable acts to be regarded as sexual harassment, which will qualify those offenders to be legally sanctioned. Essential for me to highlight that the flexibility of these provisions is made purposely as this act is subjected to social changes. Thus, the law enacted must always be adaptable despite any changes occur, or if I could characterize it, it will be a timeless law which is not restricted to only particular time and which might be irrelevant or harsh to certain period of time. In other words, it is not rigid, it will not respond to the social issue appropriately as the law might be too obsolete to address the issue. Therefore, non-exhaustive list of circumstances that may be regarded as sexual harassment will accommodate the court to interpret it broadly, adjusting it to the social conditions, not restricted to only circumstances provided in the provision. This is what it means by one of the famous scholars jurisprudence for the school, Rusty found, as law made on sociological approach is an instrument to either balancing the complex or completing interests of people in the society. Putting it into perspective, the interests of the affected people from suffering sexual harassment must be upheld as their dignity are oppressed due to such act. Therefore, a law will come into play defending the rights of the victims by taking legal actions to the offenders, humbling them down. Impliedly, both offenders and victims' interests are balanced through the legal actions. Though trauma suffered by the victims are not comparable to those legal actions imposed on the offender, but the least the law could do is to serve as a redemption of oppressed rights. I also seconded the opinion postulated by Durkheim, where he said law extracted from morality of society. Thus, if the society is contravention of morality, such as committing sexual harassment, it will put the society is immoral. Hence, law will act as a restitution instrument, putting those immoral to become immoral. Aside from sociological provisions in Chapter 2, it's also assimilated with critical legal studies, where law is reflection of political values, which most of it concerning contemporary political issues, including sexual harassment. According to this school, law is characterized as indeterminate, with which social context will prevail over stringent, scripted, standard legal arguments. Conclusion reached in any case will have more to do with the social context, which they argued and decided, than with any overarching scheme of legal reasoning. Thus, rather than making the law rigid, these provisions are modulated to be interpreted by taking into consideration the social setting. Therefore, the outcomes will not solely rely upon the wording specified in the Act, but is inclined to address that particular social conditions. As a result, the victims of sexual harassment may not only come from those provisions in this Act, but might cover other circumstances that is not provided, which cause a lot of other victims will also get equal spotlight as others, befitting the purpose. Law is so much more than black ink manifesting the impartial outcomes. Moving on, not only there is a correlation between these provisions with Western jurisprudence, but also interrelated with Islamic jurisprudence concept. These provisions in Chapter 2 is enacted to elaborate on how sexual acts might occur within society and in what form sexual harassment can appear. Islamic law can be derived either by primary sources or secondary sources consisting Quran, Sunnah, Ijtihad, and others. But on this sexual harassment context, this provision enacted based on hadith and the Sunnah and Masalih Mursalah. This is substantiated by there is an hadith by Tabrani saying that if someone's head among you is stabbed by the iron needle, it's better for you rather than groping a woman who is not his own wife. Narrated also by Tabrani, if you welted with the pig covered in mud and dirt, it's better for you rather than you lay on your shoulder to another woman's shoulder who is not your wife. Both hadiths picturize that sexual harassment are disgusting and strictly loathed in Islamic perspective. Though this hadith seems to address when the sexual violence or harassment occurs to women, but it must be bear in mind, Quran advocates equality between all and says that the only good deeds may raise the status of one human over another, not gender. In Surah An-Nisa verse 1-4 narrates that both men and women are spiritually equal. There is no such thing as restricted to only one genders are inclined to commit an indecent act, but probably around that time there is so much oppression towards women that's explaining why this hadith specified women as a victim, but in present context, sexual harassment could happen to anyone. Also, these provisions are aligned with Masalih Mursalah, as these provisions are enacted on a reason to secure benefit and remove harms. In this context, acts described in the Chapter 2 are enacted to protect all the affected victims of sexual harassment to stand by their right, purify their tainted dignity by initiating illegal actions towards the offenders, relying upon the provisions enacted. This indicates it will serve the purpose behind Masalih Mursalah contemporaneously, where it secures the benefit of those affected victims and at the same time reduce the harm that may occur to anyone aside from impertinent with sexual harassment by imposing legal means to convict the offenders. Overall, provisions in Chapter 2 are inserted to simply narrow down any probable act that comes within sexual harassment. This is vital as to not really being ambiguous on how it can occur and what type of forms that sexual harassment can appear. It serves the purpose to give mere guideline that sexual harassment not only restricted to when there is an act of physical towards another person, but it's wider than that. The act can either be regarded as sexual harassment if the offenders only communicated with by mouth, but have the effect of unwanted desire to another person, then it will jeopardize of another person's reputation. Then it may not be justified as a decent act, but more known as like indecent act, or in this context, sexual harassment.